Hi friends, we shall be discussing the topic which is becoming very popular and oft asked is what is the impact of COVID and does it amount to force majeure? Only future will say whether COVID has resulted in fact in bringing forward the impact of force majeure, but we shall be discussing the impact of COVID in the light of pure law and not in the light of the impact which it has created in causing difficulties in conducting business or due to lockdown, or where people have lost their jobs or their businesses have suffered, or industries like particularly travel sector have suffered very badly. And the, for example, aviation, tourism, hotel, they have almost run bankrupt. If not bankrupt, they have run into financial difficulties. The government is still struggling to give incentives, relaxations, and the people are saying that they are not able to perform, but they had contracted to. The impact of COVID in bringing about frustration in the obligations or contractual obligations is raising eyebrows. And we need to understand whether it does in fact amount to force majeure. Now, force majeure in law is a very narrow concept. Courts tend to take a very strict and a very narrow approach in interpreting force majeure. Force majeure is not about good conscience. It is not about equity. It's not about justice. It's not about fair play. Force majeure is something much more, much worse. And it is, that is where we say that what was contracted about has vanished and a totally new thing has emerged. Force majeure, if you see this as a phenomena causing disease which will last maybe 3 months, 4 months, 6 months, then it's a temporary aberration in law. It's not something that is permanent. It is not something which has totally changed the complexion of life. It is not something which has changed the complexion of business. And therefore, we need to understand the concept of force majeure before we begin to say whether COVID has resulted in causing force majeure. So for that, we need to understand the principles of force majeure, principles of law behind force majeure. And first of all, we need to understand that the statutory law, which gives some strength to the concept, is contained in 2 sections of the Contract Act, that is Section 32 and Section 56. Now, Section 32 is where it is contained in, it is a part of chapter 3, and it is about contingent contracts. When an event in which a contract is contingent and it to be deemed impossible if it is the future conduct of a living person. For example, the example given in section 32, under section 32, the illustration given is that A agrees to pay B certain sum of money if B will marry C. It so happens that C marries D. Now, the marriage of B to C must now be considered impossible. And that is the contingency in the contract. It is quite possible that later on C might divorce D, or D might die, or whatever happens, and C might again end up marrying B. But that is something which does not seem possible now. So there is a lot of contingency in this undertaking, where it is to do or not to do unless a certain event happens. This is the contingency, which is one part of the statutory aspect of force majeure. The second one is purely frustration, which is section 56. That is, if we agree, you and I agree to do an impossible act, then the contract is void. And for example, I agree with you to predict the prices of shares or the share market by astrology. Such an agreement is purely a void agreement, because we are doing an impossible agreement between ourselves. Now, friends, if any contract, let's understand very clearly that a contract becomes impossible if it is dependent on some future event which might or might not happen. And this is called also the subsequent events. Now, in drafting these sections, we have to understand that British were very, very good wordsmiths. They knew how to play with words. They knew how to draft. They were very good draftsmen, very good at codifying the law, and their language was very accurate. And behind their drafting is 400 to 500 years of jurisprudence, legal jurisprudence. The names that are worth mentioning are Sir James Stephen, Macaulay, and others. In India also, we can now proudly talk about 75 years or 73 years of jurisprudence. And we have very, very good case law to support. And some of the case law that we can cite to understand the concept of force majeure is very, very illuminating and very, very illustrative. For example, Banger's judgment on Justice V.K. Mukherjee, one of the best judges that India had, and the other judgment is Aloki Prasad, which was 1960, which is by Justice Shah. And then there is Nehati Jute Mill by Justice Shelat, which is 1968. And then, of course, there is Energy judgment of 2017 by Justice Rohinton Nariman. Now, friends, we when we discuss this, we will presently come to what these judgments dealt with. We will also see what was brought about by as the uh, as the approach by the Supreme Court in understanding the concept. We need to understand that force majeure does not involve any physical event. It is much wider and worse than the breakdown. The concept has emerged from vis majeure, which is natural disaster. Now, what is that natural disaster? The English law acts purely as a persuasive tool. How and what is the juristic basis of force majeure? There are three principles. And those three principles are like this. Number one, frustration occurs when an event occurs which is so drastic and so basic and it's so obvious, if it happens, it is all over between us. The emphasis is on the level of the event, the result which it has led to, that it is so drastic, so basic, that whatever was agreed between us is all over. So now, when does the frustration occur? We say the first juristic principle is that it is all over between us. Whatever was agreed, it's all over. It is such an event, and that is where the frustration has occurred. Number two, what has happened is that not what the parties intended, but when it happens, and it's a reasonable man's test, when it happens, then the courts, if courts will apply this test, that when it happens, then it changes all that we agreed upon. Now, therefore, the juristic test here is this test will be applied by the courts. And the third principle, juristic principle, is judges' standard. What is that standard? Where judges say, parties be damned, we will do justice and we will only do what the contract stipulated, and what the contract did not stipulate does not concern us. So the judges will be rewriting the contract sometimes in interpreting the contract. And that is called purely the judge-made approach. So if I may repeat here, there are three juristic principles which as I have just laid before you. First is frustration occurs when the event that happens is so drastic and so basic that when it happens, it's all over between us. That is the level of frustration, and it could lead to, and I'm only saying it could lead to, force majeure. Two, what happens is not what the parties had intended. But when it happens, it might give shape to a new situation. And that will depend on a reasonable man's test. Generally courts will apply in interpreting the event and the impact, the courts will apply this second test. The third will be judges' standard, where the judges say, let the parties be damned, I will do justice. And judge will be writing the contract, and it will be almost, judge will be writing a new contract, and it will be called purely the judge-made approach. Here, out of the three, you see the first one is too subjective. And the third one is absolutely external. First one is subjective in the sense that it depends on what I understand, you understand, or the third party understand. It's all over between us. Purely subjective on the understanding of the parties. Third one is too external, depends on what the judge understands that situation and interprets that situation. Therefore, both of these cannot be allowed. These are too vague, and the judge's concept is almost an unpredictable, unknown concept, and therefore it is called chancellor's foot. And unknown judge's power to delineate the hardship hardly meets the criterion to meet the hardship. So therefore, let us begin to understand that the approach of the court, as I said, as per the principle, as per the concept I've explained as the court's approach, is the second principle. And that is mainly dependent on objectivity. So you will see here, as I have stated here on the board, Section 56 lays a positive rule relating to frustration, and it does not leave the matter of frustration purely to the court to be determined. There can be no agreement on altered circumstances, and it has been held that if consideration of the terms of the contract in the light of circumstances when it was made shows that the parties never agreed to be bound to a fundamentally different situation, which unexpectedly arises, the contract ceases to bind at that point. Not because the court in its discretion considers it just, but on true construction, it does not apply in that situation. This was the case in Sham BD Works versus UP Forest Corporation. Now, friends, let's proceed further. Here, all other frustrations under Section 56, which fall to deal with impossible contracts, it says, unless and until it upsets the very basis of the contract, it must be such a drastic situation that it must destroy altogether the very basis of the adventure, very basis of the understanding. What is that? That the circumstances have been so basically altered, and they are so bad that it was all over what was thought as the beginning of the base or the basis of the agreement. Now, frustration cannot be a vague plea of equity, and it cannot be interpreted so easily as to frustrate the understanding between the parties to absolve them of their obligations. It is only where radically a new contract emerged. Let me not underemphasize. It is only when a totally new contract emerges, and that evolution or the emergence of a new contract is a very, very heavy burden. That burden is it's not merely due to hardship alone. It is not merely due to change of circumstances. It's not merely due to some temporary aberrations. It is, as I have said, that it should be so basic and so drastic that it should result in a totally new adventure. Now, friends, let me give you some cases where Supreme Court has interpreted the concept. First was the Banger's case, and Banger's case was where Justice B.K. Mukherjee in 1954 interpreted the concept of force majeure. The case, very briefly, was that A contracted with the developer to take over the building, to buy the building, and the building was taken over under the Defense of India rules because there was some war, and therefore two options were left: either wait until the building is released or take your money back. When the buyer sued the builder, it was held by the court that there was no frustration. It was a temporary aberration. War, after all, is going to end one day, and the military or the defense will release the building. So this is something where the war is not permanent, and it's a temporary aberration. Another case, Aloki Prasad, again had such a situation where Aloki Prasad contracted with the army to supply ghee in the peak of the war. Price was low, supply was short. He continued to supply, did not stop the supplies. And ultimately, when he asked for the compensation, he was told that there was no force majeure at all. After all, the situation of war was again not a permanent situation. It was something which was again a temporary aberration. Prices will normalize soon after the war. The supplies will become normal, and therefore there was no force majeure. There was another case, Nehati Jute Mill, where a supplier of Pakistan jute had contracted to supply and his permit was rejected. He could not perform his obligation. He pleaded force majeure. The Supreme Court held that even assuming that there was embargo, the contract was not frustrated. There was a high threshold of circumstances. Then there is fourth case. It's called energy case. And here, Adani's had contracted to supply electricity at a certain rate, and it was based on the Adani's being able to procure coal from Indonesia, and obviously the coal had to be reasonably priced for them to be able to give power at a reasonable price. In Indonesia, government of Indonesia changed the laws drastically, and thereafter the situation became absolutely difficult in Indonesia, and Adanis were not able to procure or get coal from Indonesia easily, or in any case at the same price at which they were able to procure on, or based on which they had contracted to supply power. Therefore, they pleaded force majeure. Now, here Justice Rohinton Nariman held that a great difficulty in doing something is not frustration. The situation will either change or you can procure coal from elsewhere. It is nowhere written in the contract that only Indonesian coal will be the basis of your supply, and fundamental basis of bargain could not be frustrated. There was another case in Hong Kong where a tenant had agreed to take a building on tenancy, and there the riots occurred. The tenant left his deposit and ran away. The owner sued him. The court also said, no, you cannot run away due to riots. The situation is not of a force majeure. You are bound by the contract. Similarly, there was a situation where Suez Canal was closed due to some misunderstanding between the countries, and the ships that had to carry the cargo via Suez could not go and perform their deliveries. Again, when they pleaded for force majeure, the courts in England refused to allow this situation or consider this situation as force majeure, because the court said, sorry, you can go via the Cape of Good Hope or the Cape of South Africa, but it is nowhere, it is provided that you will always use the easy route of the Suez Canal. Now, therefore, the situation is that commercial impossibility or commercial difficulty does not lead to force majeure. And we cannot overemphasize the situation, that we cannot begin to overemphasize that no matter how much the difficulty, aberration, or all this, this cannot be treated as a force majeure. Force majeure is where the parties find that the situation has, that the nature has played such a havoc that it is no more what they had intended or what they had agreed to. Uh, Temporary aberrations will never lead to force majeure. Now, many parties are, pleading here that they are not able to pay rents because they were not able to earn. Now, that unfortunately is not force majeure. However, future only will tell how long COVID will last, what ultimate impact it will have on the people or the situation or the cities or the businesses, and whether in fact the courts will consider the result of COVID as force majeure or not. It is all something that will be decided in future. But let's understand that in law, the burden of proving force majeure is a very, very heavy burden, and courts take a very narrow approach in interpreting force majeure. Thank you, friends.